my talk today, in a way, is going to be why smart contracts will lead you in the real economy inevitably to smart property. I think it's something we need to be talking more about. In another way, this is really our journey at Mattereum over this past year. We very much have been down several rabbit holes, and it's refreshing and surprising to see where it is we emerged at the end of it all. Mattereum has spent the year involved in consulting for most of the first part of the year, consulting on the legal enforceability of obligations created on smart contract platforms. We've been looking at dispute resolution procedures. We've been looking at the legal systems design. We've been doing drafting as well as coding. I don't need to tell you about the potential here. That's why you're already here. I'm actually going to focus more on two specific kinds of problem that we've found arising out of the client engagements over the course of the year. So this is something that I think, as Rutger said, it's about spotting where is there missing infrastructure, where is there some missing piece of shared protocol that is going to be necessary if people building using these new tools are going to be able to have coherent, sustainable systems at the end of it. So the two kind of problems I'm going to talk about really are obstacles on the path to real larger scale adoption for business-to-business commerce and the real economy. There's a lot that we can do, starting with smaller scale retail applications, low value. Things maybe are simpler when obligations are short term, can be performed immediately, can be verified immediately. When we get into B2B and we get into the real economy, suddenly the term of those obligations starts stretching out. We need to worry about, will this warranty that someone is offering me be worth anything in 18 months' time? So let me start with the first of the problems that we identified. And all of these issues are around real-world assets. And what do I mean by that? I mean real property, land. I mean physical property, movable property. Everything from large industrial machines through to a laptop. I mean intellectual property, something that exists only to the extent that you can pursue infringers, that you can stop other people using something that you've created. And the first big challenge that we face is, how do we stake real-world assets? How do we stake real-world assets? There's a lot of talk of staking in this community. Often it's a central part of protocols or of platforms that users or parties will have skin in the game. They will put something at stake. What if we want to stake real-world assets? We might need this if we're going to be providing secured finance, loans that are secured on real-world assets. We'll need this if we're trying to create stable coins that are based or backed by real-world assets rather than merely by purely digital assets. So it's, to me, amazing, gratifying how something like MakerDAO has survived dramatic drops in cryptocurrency prices. Because it's backed by these obligations to liquidate digital cryptocurrencies when there's a margin call. But of course, they've achieved that by having a very large margin for error. People have had to commit, what at the time would have seemed very large quantities of cryptocurrency in order to secure relatively small obligations. And the wisdom of that has become apparent, and the system has survived, which is a real achievement. But if we're going to start looking at the real economy, we're going to have to be dealing with things at a larger scale where we can't simply stake cryptocurrency. We can't simply stake the equivalent of money that is the precious liquidity we need as working capital to run businesses, to invest in R&D, to spend on expansion. We won't always be able to stake those kind of financial assets against our longer-term obligations. So we're going to need to be able to stake real-world assets. We're going to need this if we want to fractionalize interest in real-world assets. If we talk about tokenizing paintings or tokenizing buildings, there are real-world assets that are at stake in the sense that they are no longer under the control of their original owner. Someone now has an interest in it, and that interest is enforceable against that asset. What does that mean? What does it mean to stake property generally? I mean, the property has an owner, and ultimately, enforcing against an owner means that a court, and it's our courts that will uphold our basic property rights, it means that a court will override someone's property right in certain circumstances. That's what it means to have a real-world asset at stake. And this just expands into a very general problem of the enforceability of any kind of contractual obligation, including debts. We implicitly stake all of our property every time we take on a binding obligation. So all of my property, if I enter into a contract and I breach that contract, I don't perform what I promised to perform, and someone complains, we go through some dispute resolution process. It might be arbitration. They might go through litigation. And they win. The court says, yeah, you should have performed and you didn't. And I refuse to pay up. We come to enforcement. And what does enforcement mean? Enforcement means the court issues an order that overrides my property rights. I owned the things that I owned, and the court takes them away from me. It allows someone to seize my property, liquidate it, use that to pay what I owed them, and I'll get back anything that's left. So we implicitly, whether we like it or not, we stake all of our assets all the time when we enter into contractual obligations. And that enforcement it's physical. It's about, ultimately, if it gets that far, it's about someone turning up at the door and taking away my things. So, what are we going to do if we want to be able to credibly stake real-world assets? We're going to have to do this. If we simply rely on financial instruments, on money-like instruments, we're basically pursuing the opposite of trade finance, requiring people to tie up large amounts of working capital for long periods of time. It's not going to fly at scale, so this is a solution that we have to solve. Why is it more economically useful to be able to stake real-world assets? It's because they can remain in productive use even while they serve that purpose of being skin in the game and a stake. I can be using some machinery, I can be using my tools, my computer, I can be using and applying intellectual property rights even while those assets are sat there and value capital that I have that I can potentially stake against an obligation that makes me more credible. It makes you trust me more because you know either I perform or if I don't perform, you're going to be able to get compensation somehow. The second problem I want to look at is related, but it's about the control of real-world assets. So, what about where we have clients who want communities that want to organize more than just public information and organizing people's voluntary efforts? What if they need shared physical space to work? They need some land, or they need buildings. They need communal physical tools. We can't have full commons-based collaborative efforts without common access to real-world assets. It's just a requirement. But these assets, these physical things, they need maintenance. And who's going to be responsible when there's a large community that is using them. Again, this is a question of scale. If we're a small team, do we really need to worry about this stuff? No, we can have high-trust personal relationships with everyone in the team. But the whole point is that we can start supporting collaboration at larger scale, more spatially distributed. And when we do that, and yet we still need some physical assets communally available, we have to worry about who's going to be responsible for maintaining those assets. A different client case. What if this is the creative industry? What if there's creative output that is not physical, where it's about controlling access to a physical thing? What if it's non-rivalrous? What if it can be copied infinitely if no one stops it? So musical artists, should they be compensated only for live performances? I mean, this is a controversial issue in a way, especially for millennials. You know, we get used to having free or near free music whenever we want. But that's something that was created by someone who put real effort into it. Should they be rewarded for the intellectual property in their sound recordings? Or do they just have to turn up and play in person in order to earn a living? Again, who is the owner? Who's going to be responsible for that property? If it's something like intellectual property, it means ultimately enforcing against infringers. It means somebody going to court and saying, you stole that music. So I don't want to get sucked into some of the other moral and social concerns around music in particular, but the general point is this: there is valuable intellectual property. And if we want to build collaborations that use that, we have to understand how is it controlled. What does control mean when there's a group of 50 people collaborating who are creating some communal intellectual property or are using communal physical property that they're relying on for that collaboration? What if a DAO, what if a distributed autonomous organization wants to control property? What legal status does it have? Is it an unincorporated association? Is it a partnership? What's not going to work is simply saying, oh, look, we all own it. We all own it, all of us. We're all the joint owners. A court is going to look for who are the trustees or the partners? Where is the actual locus of control? And that will be where legal control sits. It will not sit with the whole. Because when it becomes to exercising those rights of ownership, those rights of property, it's not going to be practical to have necessarily a large group of people sign off on something. Now, of course, the whole point is that we want to develop new ways of collaborating and decision-making that are more amenable to large scale. And we can do that, and that's part of the key mission of DAO projects. But those projects are going to have to, if they want to use real-world assets, and my argument is that they are going to have to use real-world assets if they want to be able to start to put serious skin in the game for longer-term obligations, certainly if it gets B2B. And they're going to have to use real-world assets if they're trying to do the kind of collaboration that is based on more than just some information and organizing people's time. So we have this general problem of organizing these collaborations at scale. And there's a lot been written on this over the decades. And in particular, I just want to introduce the ideas of Ronald Coase. He won a Nobel Prize for work which included this idea of the firm or the company versus the market. And I'll explain why this is relevant. His question was, why does a company exist at all? Why don't we just prefer the market, total freedom? We can self-organize ourselves as we wish. Any group of us looking for the right qualities we want at the best prices, why can't we just come together and do that? Why do we find in the economy that we get these people gathering together in particular organizations that are companies. And his explanation was transaction costs. Transaction costs of forming the set of relationships that you need, especially for a larger group. So if you think of a collaboration as a network of relationships, as the size of that group grows, the number of relationships is growing very quickly. So if one collaborator is bringing a real-world asset that many others in this collaboration are going to need to use, that's a lot of licenses to use that thing. Who's responsible for maintaining the asset? What if the collaboration itself is creating new real-world assets? Who has the rights of ownership? Who's responsible for them? Who decides who can use them? So the court is always going to identify an owner. So as a DAO, if we want to hold real-world assets, we're going to have to resolve this issue. Who owns? How is it owned? How is it controlled? So the solution in Coze's explanation was the company. You give legal personality to the organization. And what this does is it changes the network. We go from a network of many collaborators with many different relationships between all the parties, and we shift to more of a hub and spoke model. Suddenly we have an entity, the incorporated entity, the company. And it has these spoke-like relationships with the collaborators. They can have employment agreements with the company. Now that's suddenly a lot more standardized. It's also taking a lot of the risk out of it. What's at stake between an employee and the employer is going to be a function, mostly, of the remuneration of that employee. It's no longer going to be a function of the total assets available to the business. So that is reducing a lot of risk around that set of relationships, and that set of relationships can now look a lot more standardized. At the same time, for suppliers or customers who are coming in, now they don't have this relationship with this amorphous collaboration. Now they have a relationship with one entity. It's much simpler. And when the customer or supplier is worrying about how credible is that promise, that binding promise, if it's not performed, will I have any recourse? Now they can look to one entity, and they can look to the balance sheet of that entity. What are the assets available to that entity? Because those are its stake, that's its skin in the game. And that's a very different question than if I'm looking at a large group of individuals and having to worry, well, who's staking what? Is there any, where do I have to look? Do I have to pursue multiple claims against a large number of people in order to get some compensation for the fact that their promises weren't kept? Now, of course, with the company, with corporate structure, comes some disadvantages too that we're all too familiar with. Specifically, centralization. We get centralized decision-making. Ultimately, these entities have a board of directors or trustees or partners. And that board, in many jurisdictions, can't simply delegate decision-making to, say, a DAO comprising all of the participants. In England, a director has a statutory duty now to exercise independent judgment in whether to approve a particular measure. They have a statutory duty to pursue the success of the business, of the company. So you get both the centralization of decision-making. A relatively small number of people have to make the decisions. It's their duty. Maybe they can be influenced by, they can pay attention to the views of a larger collaboration, but they mustn't simply automatically implement it. They won't be fulfilling their statutory duties. And simply you get a centralization of purpose. So even if we take an example like a US benefit corporation, where the purpose is broader, it is looking at social capital, the environment, as well as just the profit for shareholders. So it's looking at a broader set of things, but nonetheless, there's still a centralized interpretation of what that objective involves. All of the assets in the company, all of the efforts of everyone involved in that collaboration, it's all being decided centrally. So if all we want to do is organize human effort and information, yeah, we can use open source structures. We can avoid that kind of centralized control. But even then, often the platforms we use to do that will have corporate owners. And they will have corporate purposes, which they will be pursuing. And that will start to affect our ability to achieve fully self-determined, fully self-organizing purposes. Suddenly, data that we are creating in the course of this collaboration is being used and exploited for a different purpose. So, as I said at the beginning, I don't need to argue to this audience what are the potential opportunities with truly decentralized ways of organizing. But what we've learned over the course of the past 6 to 9 months at the beginning of this year is that you sooner or later, across a wide variety of different projects, you hit the same obstacles, which is when it comes to real-world assets, what is the interface between any kind of DAO-like or other decentralized structure that we create and the real-world assets that we may need to rely on and that we may want to use as part of those collaborations or that we may want to use for those communities. So we can achieve a lot with smart contracts, and not only can we organize kind of human capital and social capital, one of the major breakthroughs is we can also now organize financial capital. Smart contracts are effectively giving us programmable money, and that's huge. So not only can we organize in a self-determined way our communities or our collaborations with decision-making methods that that we choose, that we wish to adopt, but also that organization can have control over financial instruments in the form of cryptocurrencies. So truly decentralized ways of organizing and organizing human effort and relationships can also be directly reflected in the organization of financial capital. That's enormous. That's a huge step forward. But what it leaves is the other kinds of capital, the real world assets. It leaves natural capital, land, natural resources, natural sinks, regulatory environmental processes. It leaves manufactured and intellectual capital. All of the kinds of property that are out there that have owners. And ultimately, the question comes down to this. If the owner of some property turns up in a court, and it's the owner versus someone else who's pointing at a blockchain, the owner is going to win. The other person may well end up having a contractual claim. Hopefully they will have done. If we've done our job correctly in designing the legal system, there'll be solid contractual rights there. And they can go through court processes, and hopefully at the end of it, they'll get some damages to compensate them for their loss. But what they didn't have was control over a real-world asset. And to the extent that any real-world asset was staked, it was staked only through that judicial process of dispute resolution and enforcement. And what that means is that it's also less accessible to all of those businesses who are in jurisdictions which have a less reliable judicial process, if I can put it that way. There are places where it will take much longer than it takes in this country or than it takes in England to resolve a dispute. There are countries where you may not be able to rely on entirely fair process. There may be elements of corruption. And at the moment, businesses in those jurisdictions which might have most to benefit from a lot of the new decentralized tools we're creating, the possibility of collaborating on a more global scale, they cannot credibly put any kind of real-world assets as skin in the game, because if I'm in London with my contract with someone in Indonesia, and they've promised me a 2-year warranty on the diesel generators I've bought. In 18 months' time, if one of those breaks, what realistically is my chance of getting an Indonesian court to issue a writ of enforcement for me to go and seize some of their assets? The risks there mean that for even transactions of hundreds of thousands of dollars, even where we've chosen very efficient dispute resolution methods, we've opted for expedited arbitration, we can get a decision that I'm owed money very quickly. That decision is still just a piece of paper. It's still a piece of paper that I have to take to a court in Indonesia and navigate their judicial process before I'm going to actually get any compensation. If it comes to it. Often things work great, but not always. And well, I don't need to say that to an audience with many lawyers in the room. So DAOs and smart contracts and what we can construct with these decentralized platforms are not enough. We can transform how we organize and sustain human capital and social capital and even financial capital, but we can't organize property. So we need a solution to these two general problems of staking and controlling property. If only we had smart property that let us organize real-world assets in the same way that smart contracts let us organize financial assets, financial capital. Smart contracts give us programmable money. What we need is programmable property. This would be the solution to those general problems of staking and controlling that we've seen come up again and again as clients in this space try to build out platforms into the real world. So if we can do this, we can make property digitally addressable. And then the global impact of digitizing property may be as big as the global impact of digitizing information, which was huge. So this is the problem we've been trying to solve at Mattereum, is how do we deliver smart property? But it has to be more than just technologically smart property of the kind proposed by Nick Szabo. Many of you will have seen his sort of classic 1994 paper on smart contracts and smart property. He proposes embedding remotely digitally controlled locks or disabling devices in property, so that there can be this direct control by a software system over the physical thing. Now, we can't embed those kind of control systems in all kinds of objects. We can't practically secure land with just locks in all circumstances. We can't secure intellectual property with just technical means. That was tried with controls over sound recordings, and ultimately it didn't work. So smart locks can be helpful, but what we need is not just technologically smart property, but we actually need legally smart property. We need to build on courts' defense of basic property rights in most parts of the world, without necessarily having to rely on those unreliable court processes for enforcement. Let me just make that distinction again. In most parts of the world, even dictatorships with relatively poor rule of law, you're more likely to have basic property rights upheld than you are to be able to efficiently or economically complete a court-based process of trying to enforce against an asset. Even dictators have property and are quite keen on being able to hold on to it if they ever leave office. So there's a difference between your ability to rely on basic property rights and your ability to actually carry out these more complex enforcement procedures in courts. So we can't program things that don't have a digital interface, but we don't need to program the things, we need to program their owners. And obviously we can't program a person, but maybe we can program a company. So that the firm or the company was in a way part of the problem when we were worrying about centralized corporate purpose and decision-making, because it undermines the self-organizing, self-determining, decentralized projects that we want to support. But what if instead a company has a very narrow purpose, to own property and maintain it and deal with it only according to instructions from, for instance, a distributed autonomous organization or from some other distributed decentralized platform. Then potentially companies can be part of the solution. So what we're talking about here is potentially there's some need to centralize in a particular way in order to decentralize. So smart property requires programmable corporate owners with the following very limited purposes. To hold legal title, to be the owner of various different kinds of property. Manufactured and intellectual capital, natural capital. They need to maintain a register of all of the interests in that property. Has it been fractionalized and tokenized? Well, there needs to be an authoritative register of who's got claims against that property. And as the owner is best placed to recognize and make sure that those claims are enforced. Somebody needs to maintain and protect the asset. So there needs to be governance designed around the maintenance of an asset. And again, the owner is best placed to enforce that governance around an asset. There may need to be management of use of it. There may be instructions to allow various different members of a DAO to have access to certain property. Again, the owner is best placed to have actual legal, enforceable control over access. You've got potential sale of assets. You've got potential encumbrances against assets. What if I, being that Indonesian factory, want to put some skin in the game so that businesses in Europe will do business with me? Well, maybe I can do that if that asset is held by an owner who is going to follow authorized instructions absolutely in accordance with the protocol and with the rules. So what we're looking at here is, in the same way that arbitration can be an alternative to litigation in courts as a way to reach a decision on was a promise performed, should some compensation be paid, we can also possibly provide an alternative to court-based enforcement. If I'm taking a decision to a judge and saying, I want you to override that person's property rights, that's a very serious thing. And you're going to need the judicial process to accomplish that. If, on the other hand, my asset is now owned by an entity that does nothing other than hold it and act on it in accordance with authorized instructions, and because I've agreed in advance that it can do this, if I choose to enter into some obligation with someone, and I say my obligation is going to be secured on this asset, so I've got real skin in the game, and if I don't perform, and if by a process that we agree, the dispute is resolved against me, and I should compensate you, and if I refuse to pay up, then I agree that my contractual right to continue using this asset that was my asset should be terminated, and the owner will take it and liquidate it, and the proceeds of sale will be used to pay the compensation I owe, and I can have anything that's left. Then what you've just done is create an alternative enforcement process that we could rely on even in jurisdictions where we might not be willing to risk the local judicial process. So let's call these programmable owners smart property registrars, because they're maintaining a register. What this potentially allows is a global authoritative register of real-world assets. And that register can be updated, and those assets can be dealt with based on validated instructions coming out of whatever decentralized collaborative systems we choose to design. So that's the aim that we've been, certainly for the last 4 or 5 months, working towards? What does the protocol look like for the operation of that kind of entity? Because you'd better be able to trust that entity, because it owns your stuff now. And if you need to enforce against it, you're in the same difficult position that anyone is, where someone else owns the property and you've got a merely contractual right. So the Mattereum protocol that we're developing is not just a technical protocol, it's also a legal protocol. These entities need to be extremely constrained in what they can do. They're still going to have centralized decision-making around a board, but their constitutional documents are going to have to be amended, the Articles of Association or the bylaws, so that decisions can only be made in this particular way, with this kind of notice. And there will be this number of independent directors available. And these technical measures will be used to carry out any valid decision-making process. So what we do here is we're using the technological tools available to us now in order to ensure transparency where we need transparency, and to ensure privacy where we need privacy. So the protocol around how smart property registrars operate is in itself a very important use case for cryptography and for distributed ledgers. Even if we don't then use smart property in order to interface with smart contract-based systems. Even if I enter into a contract written on paper in ink with a counterparty in a jurisdiction I otherwise wouldn't trust. If we've handwritten out an enforcement clause after our arbitration clause that says, and by the way, we've got these assets are registered, and we agree that they should be used to secure our obligations, then that credible skin in the game is available even for paper contracts. But of course, we can do so much more in that these real-world assets are now digitally addressable. So we have to go further. It's now going to be very important that we limit the liability of any company that wants to play this role of registrar. It's very important that they don't trade, they don't start taking on obligations where they too might fail to perform their obligations, because that's then going to put the assets that they hold at risk. So just as in the same way as any special purpose vehicle maybe for a joint venture or for some other purpose is created to be as remote as possible from insolvency, these generalized special purpose vehicles, if I can call them that, need to meet the same standards. So they absolutely will not be taking on responsibility for anything around the original title in that asset, or its provenance, or its valuation. So there has to be again, an unbundling of responsibilities, a decentralization of liability, so that it's an ecosystem of experts who understand how to establish the provenance of a car, say. And there are plenty of those. It's not as though we lack people who have expertise in establishing the provenance of a car. People who can value, people who are willing to assert that, yes, the original owner did have legal title to it. They are in a position to transfer title onto the register. So what we do is, if I can contrast it with the development of the law relating to trusts, certainly in English common law, and I'm beginning to learn about some of the sort of equivalent solutions in civil law systems. Because of the difficulty over lack of transparency of record keeping, lack of ability to have any meaningful control or oversight of assets as a beneficiary who is quite remote from a trustee who has the greater control over property, the legal solution to that problem was simply to put all of the responsibility on the trustee. That person is then fully accountable for whatever happens to that. So it's an extreme centralization of responsibility, but it was a solution to a problem that existed. What we're looking at here is the use of modern technology to be able to find alternative ways of solving those problems. We don't necessarily need to bundle up all responsibility into a single entity. We can credibly now maintain high degrees of transparency and standards of record keeping. So these are different legal solutions that are enabled by technology. And this is the reason why something like this simply wasn't credible, say, in the middle of the 20th century, but can be credible today. A further advantage of this kind of decentralized system, if we go back to COES, is we're able to take more advantage of market-like behavior than centralized company-like behavior. So again, if I'm operating a trust company and I'm fully responsible for all aspects of an asset, that puts me in a, even to the extent that I may be able to subcontract something, but I'm still responsible for choosing the subcontractor. I'm still going to be negligent and held to account if something happens to the asset. What we're looking at is a very different model with much more constrained contractual limited liabilities in respect of well-defined functions. And as far as possible, what we're trying to do is move from open-ended liabilities in tort, where someone might be negligent and perhaps face unlimited liability, potentially, if all of the elements of their negligence can be made out, and move that, where possible, to a more explicit contractual basis. So again, when it comes to verifying identity, when it comes to verifying the authenticity of an instruction to deal with an asset, it will not be the registrar node that verifies that. It will be the responsibility of one of the various ID providers to certify that that instruction was valid. And if we think of an analogy, if today I need to show a potential counterparty a certified copy of my passport so that they can be confident that I am actually the director named on the company register, that they are dealing with this company. Today, I will go to a lawyer in London, and they'll kind of look at me and look at the passport, and they'll take a photocopy, and they'll sign off that it's a certified copy. I give that copy to my counterparty. Now, if it later turns out that this was fraudulent, potentially that counterparty now has a claim against the lawyer. The lawyer was negligent. But they didn't bother negotiating any terms for that relationship. It's a claim in tort. So the lawyer potentially has unlimited liability. And it's in a much worse position than if we'd moved all of this to a more explicit contractual basis, and the lawyer knows exactly where he stands or she stands in signing off on the authenticity of a particular instruction. So again, we can do a lot with public-private key cryptography. We can do a lot with distributed ledgers. But what it also enables is different legal solutions to problems that we inevitably face with any kind of collaboration at scale. So I'm coming to the end. So in conclusion, smart property comprises an unbundling and a fractionalizing of the rights of ownership. So, those different rights that we might identify classically: possessing, managing use, receiving income, alienating, realizing the capital value that way. So it's an unbundling of these rights and a potential fractionalizing of them. And smart property is also both a legal and a technical system, or systems design that is redrawing the boundary between proprietary rights and contractual rights. And it's shifting that boundary to allow us to do more in the realm of contract, because that's where we have greatest flexibility to design it appropriately, and it's where we have the greatest scope for consistent global interpretation. So we can't do anything to change what enforcement looks like in various different jurisdictions. Those are long-term projects. Maybe those jurisdictions will eventually have rule of law. Maybe they won't. What we can do is, as far as possible, do what we can in the realm of contract where we do get choice of law, where we can design it and put the effort in up front to make these function in the way that we want, where we can have systems for interpretation like arbitration, where we define the procedures and we define the mechanisms that those arbitrators will be appointed, and we define which substantive law will be used to interpret those obligations. And we have all of the other technological solutions we now have available for the recording of evidence of performance that makes resolving disputes more efficient. And what we get at the end of this is more programmatic control of real-world assets on a more consistent global basis. And that, we think, is a key part of the kind of infrastructure that Wray was talking about. Once we have this kind of protocol around smart property and the ability for any new decentralized project to interface not only with people and with financial capital, but with real-world assets, then we can let 1,000 flowers bloom. We can try many different experiments. I certainly don't claim to understand now what will be the most successful of the new organizing systems or decision-making systems. Where will quadratic voting be the thing that makes a difference? Where will some of the other self-organizing approaches make a difference? I don't know, but what we see as our task is if we can define the right protocol to support, the right infrastructure to support those kind of experiments, then the world that it will enable is going to be a better world than one in which often any kind of collaboration at scale, especially any kind of collaboration that involves real-world assets, tends to be highly centralized, and it tends to have that centralization of decision-making and the centralization of corporate purpose that we get when we deal with companies and firms. And then finally, having a global smart property register in the kind that I've described potentially increases liquidity by now supporting partial transferable interests in registered assets. It underpins the global enforceability of commercial obligations by allowing them to be secured against registered assets. And it enables distributed autonomous organizations and other new organizational forms to control manufactured and intellectual capital and natural capital, as well as human capital and social capital and financial capital. So the new technologies that we're developing, that we're building, get to organize all of the kinds of wealth and input that are available in the world, and don't need to remain restricted to just people's time and information and money. So that's what I wanted to present today. I know we have some time a little later for questions and for more interaction, and so I hope that some of you will come to that, because I would love to dive even deeper and explore many of the details and issues around this. Thank you very much.